Major breaking news out of the United States District Court for the District of Illinois, the Southern District of Illinois. Judge Stephen McGlynn, as predicted on this channel, has issued a 160 some odd page opinion striking down, declaring as unconstitutional under the Second Amendment the Illinois bans on semi-automatic rifles and magazines that hold more than 10 rounds and then some. This is a major win for the Second Amendment. This is on the heels of those terrible anti-gun decisions by Judge Easterbrook and Judge Wood in the United States Court of Appeals for the Seventh Circuit that ruled against the Second Amendment and sent the case back down to Judge McGlynn, who has just now powerfully defended the right to keep and bear arms. Let's break it all down when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new, critically important, in my view, law review article in the Georgetown Journal of Law and Public Policy about how to apply the Second Amendment in Second Amendment cases, the different mistakes that the lower court judges have been making, and how to get them fixed. If you're a scholar, if you're a historian, if you're a lawyer or a judge or a law clerk in the law, you're going to want to read this article just published in the Georgetown Journal of Law and Public Policy by yours truly, a detailed analysis to make it practically understandable to apply the Second Amendment. Check it out. A link to that article, which is free, is in the description of this video. All right, we have major breaking news in the case. There's actually multiple consolidated cases of Barnett versus Rao. This is a big win, by the way, for many organizations, Gun Owners of America, the Second Amendment Foundation, Firearms Policy Coalition, the California Rifle and Pistol Association, the NRA, and so on and so on. Congratulations to all those groups. Federal District Court Judge Stephen McGlynn, after a week-long trial, has just issued a 160-page opinion saying that the Illinois ban on semi-automatic rifles, magazines that hold more than 10 rounds, are unconstitutional under the Second Amendment and unconstitutional, equally important, under the flawed, ridiculous reasoning of that absurd three-judge panel in the Bevis case of Judge Easterbrook and Judge Wood in a 2-1 decision over Judge Michael Brennan's dissent, which is really the law of the land, but set that issue aside. So it's very good to see that Stephen McGlynn, following the absurd rulings of Judge Easterbrook and Judge Wood in the Bevis case, still found the obvious answer, which is that the right to bear arms protects and prevents banning semi-automatic rifles that are in common use by Americans for lawful purposes and banning magazines that do the same. Let me tell you what he wrote first and foremost. Judge McGlynn writes, quote, "Most importantly, considering all the evidence presented, the court holds that the provisions of the Illinois statute criminalizing the knowing possession of specific semi-automatic rifles, shotguns, magazines, and attachments are unconstitutional under the Second Amendment to the United States Constitution as applied to the states by the 14th Amendment. Therefore, the plaintiffs, the Second Amendment plaintiffs' request for a permanent injunction is granted. The state of Illinois is hereby enjoined, that means stopped, enjoined from the enforcement of the Illinois criminal penalties in accordance with the various laws dealing with bump stocks and assault weapons and attachments, and large capacity magazines, all against all Illinois citizens, effective immediately. As the prohibition of firearms is unconstitutional, so is the registration scheme for assault weapons, attachments, and large capacity magazines. Therefore, the state of Illinois is enjoined from enforcing the firearms registration requirements and penalties associated with entering false information on the endorsement affidavit for non-exempt weapons, magazines, and attachments previously required to be registered in accordance with the relevant statute. This permanent injunction is stayed, which means put on pause, by the way. This permanent injunction is stayed for 30 days. The clerk of the court is directed to enter judgment in favor of the plaintiffs. It is so ordered." That's powerful language. That is the end of the decision, 160 some odd pages. There's another 40-page related opinion on some evidentiary issues. But the bottom line is he found all these laws to be unconstitutional. He has enjoined them, but he has stayed his order basically to allow the state of Illinois the chance to seek some sort of reversal quickly from the U.S. Court of Appeals for the Seventh Circuit. But listen carefully. This is extremely good news, what I'm about to say. Get ready to clap your hands. Ready, folks? That three-judge panel that threw us under the bus in the Bevis case, which likely would have been the three-judge panel to hear an immediate appeal from this decision, does not exist anymore. Why do I say that? That terrible awful anti-Second Amendment panel of Judge Easterbrook and Judge Wood, with Judge Michael Brennan, the one dissenter, the one guy gets it, is no more because the anti-gun, bitter, angry judge, Judge Wood, who's upset she never got on the U.S. Supreme Court, has officially 100% retired entirely from the federal courts. She is no longer a judge anywhere in America. She has moved on, which means that even if they try to reassign to that same three-judge panel, Judge Wood, who got it entirely wrong, will not be the judge. We will get a different judge, maybe even a different panel, but at a minimum, a different judge, and thus by extension or by implication, a different panel, because Judge Wood, who's terrible on guns, is no longer on the U.S. Court of Appeals for the Seventh Circuit or otherwise in the federal judiciary. This is very good news because we'll see what happens, because someone's going to go to the Seventh Circuit. That's what Illinois is going to do, and we'll see what that Court of Appeals does. But let me carry on. This is powerful language also in support of the Second Amendment. Some of the best language you'll hear by Judge McGlynn or anywhere else. Here's what he says to kind of basically lay out the introduction of his major decision. I think you'll find some of this quite familiar because it's the sort of thing we talk about on this channel. Check it out right here. Judge McGlynn writes, quote, "Why are there small lifeboats on gigantic steel ocean liners? Why do we spend thousands equipping our vehicles with airbags? Why do we wear seatbelts and place our infants in safety seats? Why do we build storm shelters under our homes? Why do we install ground fault interrupter outlets by sinks and bathtubs? Why do we get painful inoculations? Why do we voluntarily undergo sickening chemotherapy? And why do we protect ourselves with firearms?" Judge McGlynn continues, "In life we face many perils. Some are natural weather phenomenon, such as hurricanes, tornadoes, or floods. Some are biological, such as viruses, disease, and malignant cells. Some perils are associated with important products like electricity, natural gas, matches, automobiles, and pain-relieving medications." He sets up the stage beautifully. Notice how he did that? He's really making the point that we've talked about on this channel, that people own life insurance, we own fire extinguishers, we own all sorts of things in anticipation of the possibility that rare events can come to fruition. And luckily and thankfully, the Second Amendment's right to keep and bear arms is and does speak to rare events. It is rare that we need to actually use guns to overthrow a tyrannical government. It is rare that we have to deal with domestic insurrections. It is rare that we have to confront face-to-face violent thugs or terrorists or rabid animals. These are rare events, but that's the whole notion of the Second Amendment, to allow us to make sure that we have the right to keep and bear arms in the event these events that do occur but are rare, we're ready for them. It's about preparation, and that's the way to think about it, as did Judge McGlynn in ruling in favor of the Second Amendment against those onerous unconstitutional laws in the state of Illinois. There's a lot of great language that Judge McGlynn uses. Here's another great point he makes in his major opinion in support of the Second Amendment. Judge McGlynn writes as follows: "While both members of the military and civilians may be called upon to engage in confrontation, the civilian is often an army of one and has no backup, no support, and no reinforcements in the moment when home confrontation occurs. They will often not have the same physical fitness abilities as trained professional soldiers. Moreover, they may not have the benefit of military training and conditioning on which they can rely in a life or death scenario. The life and death stakes mandate that their firearms have both lethal capabilities and give, at a minimum, our citizens a fighting chance. Therefore, sorting between military use and private use is an exercise in understanding civilian self-defense. One cannot properly address the scope of the Second Amendment without understanding the complex dynamics of self-defense in which lethal force may be required to repel a rapist, a murderer, a kidnapper, or a stalker." Powerful language by Judge McGlynn. Again, I'm going to put a link to the big decision down below. We'll do a couple more videos about this. Again, this is great news for Illinois. The better news, the best news we can all cheer for now that Donald Trump has won the White House and the Senate is going to be controlled by Republicans, thus allowing us to appoint federal judges and new Supreme Court justices, a huge victory for freedom in America and the right to keep and bear arms. Now we need to all cheer We need to light the candles. We need to pray to our gods, whatever it is that it takes, to get the U.S. Supreme Court to grant cert in the Snope case, which is the semi-automatic ban case out of the state of Maryland through the U.S. Court of Appeals for the Fourth Circuit. We will know about this to start in December. We will have a final decision on whether or not they're going to hear the case in January. And let us hope and pray that the Supreme Court grants the Snope case. And if they do, I suspect they'll be looking to some degree at some of the powerful language and decisions and findings by Judge McGlynn in this case of Barnett versus Rowell and others. So congratulations to those 2A groups out there and the 2A lawyers that fought hard for us in Illinois. We'll keep you abreast as there are developments. We'll see what happens to the U.S. Court of Appeals for the Seventh Circuit. But at a minimum, we know that Judge Wood will not be able to participate and throw us under the bus and to throw the Second Amendment under the bus because she's no longer a federal judge. Yes, good news for us and for freedom. All right, folks, hope you learned something here today. Make sure you follow me on X at 4 Boxes Diner, almost 19,000 followers over there. And we're trying to grow the channel, get to 200,000 subscribers here. Make sure you share this video and like the channel and like the video and all that good stuff. And we will see you again very soon, I hope, here at the 4 Boxes Diner.
Orders up. Table 2A.